4652. Who do I have here for this?
Good morning, Your Honor. Ramzy Ladah for plaintiff.
Okay. And defense?
Good morning, Your Honor. Paterno Jurani for defendant Collins.
Okay. This is plaintiff's motion for leave to amend. I did look at the pleadings. This matter was also pretty delayed at the request of defense counsel all along. So I'm happy to hear argument, but I want both counsel to understand that's the position I'm coming from, that this matter, because I understand the argument that the statute of limitations has passed. However, this matter was greatly delayed, and even the responses to discovery were delayed at the request of defense counsel because of the associated criminal matter. I'm happy to hear argument, but I want counsel to understand that I am taking that into consideration as well. Okay? So, Mr. Ladah, it was your motion, so go ahead.
Thank you, Your Honor. So, as you know, we filed a lawsuit long before the statute of limitations. We served an interrogatory April 28th of 2022 asking if Mr. Collins, if Zaon Collins is the owner of the vehicle, and if not, who else is the owner of the vehicle. Defense counsel did not respond to the interrogatory. There are numerous different status checks. Defense counsel files a motion to freeze or stay discovery because there's an ongoing pending criminal case, as you know. So we don't get the response to the interrogatory until, I believe it's May of 2023. Once we finally get the response, end of March 2023, March 31st, 2023. When we finally get the response, I call up Mr. Cannon. Mr. Cannon says, he actually says on the phone, yes, I will stipulate. Then we send him numerous emails with stipulations, and he doesn't respond to them. I understand he had some health issues or medical issues, so that's why he says he didn't respond to us. So because he wasn't getting back to us, when he finally got back to us, he said, no, I can't stipulate, so then we file our motion. Of course, Your Honor, we were diligent all along. We filed this interrogatory about 30 days after the JCCR was filed, which was long before the statute of limitations. If they just responded to this interrogatory timely, we would have moved to amend before the statute of limitations. Defense counsel's argument is, oh, well, we sent you a letter tendering the policy limits, but my client's not accepting the policy limits, so I don't know why that's relevant. And that email they sent tendering the policy limits doesn't say anything about Marvin Collins. It's referring to Zaon Collins, because the case is against Zaon Collins, first of all. Second of all, they also say, oh, well, the declarations page showed that Marvin Collins wasn't insured. The declarations page doesn't say Marvin Collins owns the vehicle. So how would we know he owns the vehicle? You can be insured on a vehicle for a number of reasons. For example, bundling with different policies, with different vehicles, family vehicles, vehicles involved with owned by numerous different individuals in the family. So then they argue that somehow we should have known that he was an owner, but we had no information that he was an owner. If you look at the police report, Your Honor, the police report says Zaon Collins was the owner of the vehicle. We had no other information indicating otherwise, and that's why we served the interrogatory within 30 days of the JCCR, which would have given us roughly 5 or 6 months before the statute of limitations if they just responded to it timely. They're the ones that requested the delay. They're the ones that wanted to freeze discovery. They're the ones that had no explanation, any of the status checks as to why they weren't responding to interrogatories. They're the ones that didn't get us a response or any information that he was the owner of the vehicle until long after the statute of limitations. There's no delay on plaintiff's part. It's their fault. The rules contemplate this type of situation. If you look at the NRCP, Rule 15 and Rule 15A and 15C both contemplate this type of situation. The case law contemplates this situation. It's only fair, it's only right, it's pursuant to the rules that we should be able to amend our complaint to add Marvin Collins as a defendant now that we know he owns the vehicle. If we did so prior, Your Honor, we would have been violating Rule 11 because we had no information that he was the owner of the vehicle. With that said, Your Honor, I'll submit it.
Okay. Thanks, it's your motion, so you'll get to You'll get the last word after Mr. Defense Counsel. Go ahead.
Thank you, Your Honor.
Yes, Your Honor. But I disagree that they were diligent. You know, something with the importance of statute of limitations, you know, I don't think it's appropriate at all that they just waited for us to respond to interrogatories, especially knowing, you know, we had ongoing, as you mentioned, motions to stay. There was no mention during those pleadings that I recall saying that we need these responses because we need to know who the owner of the property or the owner of the vehicle was. I mean, Your Honor, under the totality of the circumstances, I mean, we had a 19-year-old defendant. Unlikely that someone that age has a 2016 Dodge Challenger under his name. We did send an email on February of 2022, which included the declarations page. And that declarations page, it does say Marvin Collins. It doesn't say Zaon Collins anywhere. It doesn't list him as additional insured. At best, he's a permissive insured. Under these circumstances, Your Honor, the investigation was warranted. You know, they drafted an interrogatory, but as soon as we did motions to stay. I mean, as I said, they never mentioned in the pleadings for the brief for the motion to stay that, hey, we need this response. We need to know who the owner was. You know, frankly, this is the kind of thing that probably could have been handled by a phone call. You know, give us a call. Hey, we got statute of limitations coming up. We need to know who the owner was. Instead, they basically just sat on their hands. I think under these circumstances, Your Honor, I do not believe they were diligent. I think at best they were careless. They had noticed that Marvin Collins was potentially the owner of the vehicle, and clearly that's the case because they included it in an interrogatory. They just didn't do anything after that to receive a response to that request, and then they let the statute of limitations pass. You know, the February 2022 email. I mean, that was 10 months before the expiration of the statute of limitations. As I said, in that time, they could have said, "Hey, we're coming up against statute of limitations. We have to do something to know whether or not to add Marvin," and they just didn't, Your Honor. I disagree that they were diligent, and their motion should be denied, Your Honor.
Okay. Before I let Mr. Ladah respond, with a deadline of November 30th, 2023 for the last day to amend pleadings and add parties, as well as the last day to disclose initial experts, if I'm inclined to grant this motion, how is the new party, which I assume you're going to be representing as well, how is the new party prejudiced?
I think it's the ultimate prejudice, Your Honor. They have to defend against the lawsuit where they wouldn't have because statute of limitations passed. I mean, you know, I can't imagine a worse prejudice.
But then why did you agree, or why didn't you oppose setting the last day to amend pleadings and add parties for the date we set it for, which was after the statute of limitations? Because we have rules that allow relation back clauses, and depending on how the complaint's drafted. But we also purposely set a deadline for last day to amend pleadings and add parties in this that happens to be November 30th, which at this point is, you know, more than 90 days away. So
Understood, Your Honor.
We're sitting on this case as it is, with this motion being brought before that deadline. I understand your argument that you probably you definitely would have preferred that they brought it earlier, but discovery hasn't been that extensive yet in this case because of requests from the defense side to continue this so that the criminal matter could be addressed. So is 90 days not going to be enough time with the new party added to do discovery before the initial expert disclosure? Do you think that's going to be the problem?
I'm not sure, Your Honor. I'm not sure what kind of, I imagine they would send additional discovery related to Marvin Collins.
Do you know if you're going
There
to
would
be
be-
representing the additional
I
Mr.
do.
Collins if he's brought into this matter, or do you not know yet?
I do not know.
Okay. Okay, anything else you want to add or any additional information you want to give me, whether based on your own argument or some of the questions I just asked or points that I just requested that you respond to?
Your Honor, only that as far as Mr. Cannon agreeing to a stipulation, as you know, it's customary to send a confirmatory email. There was no evidence of any email. That's all I have, Your Honor. Thank you.
Oh, there's an email response from Mr. Cannon that's attached to the pleadings. Is that what you're talking about?
Well, what I'm talking about is their motion claims that Mr. Cannon agreed to stipulate to add Marvin Collins, and typically when that would happen,
Oh,
Mr.
okay.
Ladah's office would send a confirmatory email.
Okay, so you just want to make clear for the record that there was no prior agreement that this that this additional party could be added, right?
Yes, Your Honor.
Okay, I understand. Okay, thank you very much. Mr. Ladah, any response?
Just briefly, Your Honor, we have no opposition to extending out the deadline for experts or to add parties if defense counsel requests that. He doesn't know whether he's going to be representing Mr. Collins yet, so maybe we should wait to see who represents Mr. Marvin Collins. But as far as his arguments regarding the timing, Your Honor, the email they sent says nothing about Marvin Collins being the owner of the vehicle. The declarations page says nothing about Marvin Collins being the owner of the vehicle. This is why we sent an interrogatory early on in the case to discover if there is another owner of the vehicle. They're the ones that didn't respond to the interrogatory. They're the ones that requested a stay of discovery. We oppose this. The idea that we sat on our hands is ridiculous. Sending an interrogatory to get the information is not sitting on our hands. Opposing every single request to stay discovery that they file is not sitting on our hands. They're the ones that tied our hands and prevented us from gaining the information that we needed to defeat a Rule 11 violation and file a motion with Mr. Marvin Collins as a defendant. Without that information, we cannot add him as a defendant under Rule 11 without violating our ethical obligations to the court. Your Honor, we did everything appropriate in this case. The rules contemplate the situation. It's not our fault that anything's delayed. With that said, Your Honor, I'll submit it.
Okay. I'm going to grant the plaintiff's motion for leave to amend the complaint to add Marvin Collins as a defendant. I also would be open to signing a stipulation order to further extend the deadlines if the new counsel coming in, if there's new counsel coming in, needs additional time. If current defense counsel is going to also defend Marvin Collins and additional time is needed, I encourage counsel to please work together to submit a stip. But I'm going to grant the motion. If you do submit a stip asking for more time, please just be reasonable because this matter's already been pushed out quite a bit of time. And it would be great to get it moving through discovery and prepped for trial. So any questions?
Not for plaintiff's counsel.
Okay, Mr. Ladah, can you please submit a proposed order, run it by defense counsel first for form and content, and then submit it to my chambers?
Will do. Thank you, Your Honor.
Okay, thank you. Thank you, have a good day.
You too.
Thank you, Your Honor.
Thank you.